support, impede entrepreneurship? What do we need to think about intellectual property going forward? And we have an enormously distinguished panel. I'm just going to introduce them here as you see them sitting to your right and to my left. Immediately, we have Professor John Duffy, who's a professor of law at the University of Virginia, and he has an enormously distinguished background. Like a lot of people who found themselves becoming experts in patent law, John started life as a physics undergraduate, as I remember, and then went on to be the notes editor at the University of Chicago Law School. He clerked for an appellate judge and clerked for Mr. Justice Scalia, who, believe me, having gone to law school myself, I have a vivid sense of how rare it is to clerk for a Supreme Court justice. It's quite a compliment. But even in addition to multiple publications, you have them in the bio there in front of you. He also has been named one of the 25 most influential people in the United States and one of the 50 most influential people in the entire world. So speaking as a country boy from Oregon, I'm odd to be in this.
IP, that is. Very narrow subject. To John's left is John Dudas, an old friend. John is, again, has a very strong background in intellectual property. And under President George W. Bush, he was the Undersecretary for Intellectual Property, ran the Patent and Trademark Office, and was, in fact, quite an innovator and entrepreneur while he was in that office. And speaking of entrepreneurship, he has now gone on to become president of FIRST, U.S. FIRST. This is, as you probably all know, a program to get young people excited about math and science. And in many ways, you see the high school program is, in a sense, a group of people who are bringing a new product to market. So he's really not only stimulating interest in math and science, but creating an aura and an ecosystem in which entrepreneurship can thrive. And to John's left is Doug Comer. Doug also served at PTO. He was the deputy director of PTO under H.W. Bush, I believe, and went on then to be really the law and technology guru for Intel as their presence here in Washington. He co-founded a task force on the future of American innovation, which has become a real force in terms of articulating the importance of innovation to the American economy and to the American future. And to Doug's left is Steve Merrill. Steve is the executive director of the Science, Technology, Economy program at the National Academies. He has run that program with distinction for many years, did a great deal of the intellectual work and research behind what became the recently passed patent bill. He also had a distinguished career on the Hill. It seems everybody's had that in their background.
Also Senate.
Yes, that's right. And those of you who remember the Stevenson-Weidler bill, well, Steve worked for Senator Stevenson at one point in his distinguished past. Well, I think we're ready now with the video, so I'm going to ask John Dudas to start us off. And then because we're in danger of losing the webcast here at 11:45, I've asked the presenters to keep their remarks to 10 minutes or so, and then we still will have plenty of time for questions.
Sounds good. Thanks a lot. I'll come back to this. This is the dessert, I guess, of what I was going to talk about. There's probably way too many topics to talk about. I found the last panel to be really thought-provoking. It led to all kinds of different issues. So I sat down and just took notes and decided I would hit that. Talk a little bit about my experience at the Patent and Trademark Office, what I see as issues, and then I'll move into what I think is an even bigger issue in terms of innovation and entrepreneurship and what we need to do in the United States and throughout the world to inspire more innovation. But one of the issues that I would raise, if I'm looking right now, just today as we were sitting down talking, 4 ideas. Again, these are broad, big ideas, not very focused on what are some of the biggest problems in the patent world. One is one Mike brought up in the last panel, which is overlapping patents. I'd love to think of intellectual property, and often do, as like real property deeds. And in a lot of ways, we can create a lot more entrepreneurship and innovation if we do that. But there is an issue that land deeds are a lot more, they can be clouded title. You can have overlapping issues and things like that. But there are issues about ideas overlapping. One that we didn't talk about is overlapping patent systems, right? So we all know how we're a global world. Everyone realizes this, but I don't know if people realize how huge of a problem it is. You can collaborate throughout the world. You can collaborate instantly. You can bring products to market through teams that are international, but patent systems aren't international. Less than 1 in 5 people in the United States of the general public even realize that a U.S. patent is only good in the U.S. So not only is it an issue, people don't even realize it is an issue. One of the biggest issues I saw while I was there was not only do you have to deal with a lot of patent systems throughout the world, every country you want to deal with. Europe has an overall patent system, but even that, they don't have quite figured out how they're going to enforce things in a uniform manner. You have patent systems throughout the world. Wherever you want to go, you have to deal with their patent system. And you have redundancy across the board. We're all trying to come up with basically the same answer, which is this a new, useful, and non-obvious idea? There's differences throughout the system, but essentially there's huge problems in that. If you want a patent in China, you need to deal with the Chinese system, in Japan, the Japanese system. To make matters worse, from a policy perspective, countries want to go in different routes. So the United States, Europe, and Japan at one point were 85% of the world's patents. It's down to below 55% now. China, the 8 millionth patent was just signed recently. It was celebrated. During that time, someone told me, John, you signed 972,000 patents. So due to a circumstance of fate, how long I was at the patent office, everything else, I now hold the record for signing more patents than anyone in the history of the world. The next person who will probably sign more patents than that in the next 2 years is Tian Lepu from China. And those are utility patents, essentially, the same kinds of innovative, inventive patents that are there now. It's not a bad thing. It's just not something people would expect. They would expect that the number 1, 2, 3, 4 would probably be the United States. China was probably the most important in terms of where were they going. China, Brazil, and India, particularly Brazil, from a policy perspective, often takes a different approach to intellectual property than the United States, and not nearly as strong pro-IP. Whether it's right or wrong what we do in the United States, Brazil goes a different route. India followed that route for a long time, and a lot of other countries do that. So there was talk about what happens in Brussels, talk about what happens in Geneva. It makes a big difference in terms of if you're going to have, what policy you're going to have, international patent policy, if you want to practice throughout the world. It became clear China wanted to live in both worlds. They wanted to be considered a developing nation when it came to the aid that comes along with that and the breaks that you get internationally. But China also, we have to recognize they have 500 million, 600 million people out of poverty. They have a huge economy of people that are even in sort of a developed type of situation. So we spent a lot of time making sure that China would become part of the system that was US, Japan, and Europe. And we also asked Korea to be a part of that. So one of the biggest things I think that's a difference now, we're still a long way away, but China, Japan, the United States, Korea, and Europe are all working together on a technical basis to make certain that they can figure out what we need to do with the patent system throughout the world, how we share data, how we share results, how our systems should probably interact and work together while respecting internationally our sovereign nations, and that we have differences in law. So I'll just raise these as issues that we can raise. The other thing I think that's a huge issue before us in the patent system today is bad incentives. I think there's bad incentives for getting patents. There was a time when if you were getting a patent, if you have innovation, you want to protect it with a patent most times. So that became a situation where people thought, well, if getting a patent means you have innovation, or if you need to get a patent, if you have innovation, then that must mean if you have patents, you're innovative. And it started to become a measure and a metric. The more patents you have, the more innovative you have. Well, the problem with that is patents it can be very expensive, but in terms of if they measure how innovative you are, they can actually be pretty cheap. So I think we have a real incentive system out there now in lots of ways where people are getting patents for reasons other than that they're going to be innovative. It could be reasons like, if I have a stack of patents, people are probably familiar with the cross-licensing arrangements that we have now. We have huge high-tech companies doing exactly the right thing from themselves, from a fiscal responsibility standpoint, where if they have a pile of patents and they see a competitor, they're ready to sue. And the competitor says, that's great, you sue me, I've got 10 patents, I'm going to sue. I've got thousands and thousands of patents, 10 of which you're violating as well. I'm going to sue you. And they work it all out, and they agree with each other that they'll cross-license. I won't sue you with any of your patents. You won't sue me with any of your patents. Well, that's resulted in some cases, I believe, that companies have said they want a whole lot more patents so they can be able to cross-license with more people. Some people would argue that's why Lenovo bought part of IBM. Some people would argue that that's why Google bought the patent portfolio at Motorola. So there are these entire piles of patents that people are trying to set up along those lines. Standards. in standards, international standards, it should be whoever has the most important intellectual property, the most important ideas should get the most, but arguably in some countries it matters how many patents you have. So if you have more patents, you get more of an opportunity to get a greater percentage of what's happening in a standard, so now you have another reason to get a patent. We had companies that came in, Fortune 5 companies, not 500, Fortune 5 companies that would say, if I don't get the same number of patents I got last year, if I don't come out in the same top 10 list that I came out in last year or better, I'll be fired. And these were senior VP, C-suite types of people. They just need more patents because that's what the metric that they had. Now, is it right or is it, well, I don't think it's right, so I won't even say is it right or is it wrong, but I'll leave it for other. There's bad incentives in the system. I think there are other types of things that are bad. To me, another problem I find is the whole subsidy system that we have in the patent system creates some level of problems. While I was undersecretary, we put quality initiatives into place. People argue whether they were right or wrong. The allowance rate dropped dramatically from in the high 60s to settled around 45%. I think it as quality initiatives, we saw quality measures show what we believe was higher quality. We saw that the allowance rate went down. The allowance rate continued dropping well after that. So there was a question about whether or not we sent a message that rejection was better. But the issue there is that the system is funded dramatically by successful entrepreneurs, successful innovators who get their patent. You pay higher fees if you get your patent. So what we have, though, is a system, particularly if allowance rates are dropping or if allowance rates are lower as they are now. They've started to go back up. But if allowance rates are lower, what you have is the people who are successful at getting patents are funding the people who aren't. And there's a lot of reasons why sometimes people aren't successful. It could be that the patent examiner is just wrong. It could be that it was bad to begin with. It could be that people are going back through the system a number of times because that's a good strategy. But the point of it is if you're somebody who gets through the system and you're successful and you get through quickly, you end up paying for people that sometimes takes 4, 5, 6 times around to get through their system. It seems to me it's a bad subsidy. It's a bad system. The other issue is I don't know that this is truly an issue. I didn't feel like it was while I was there, but it was very clear that as the allowance rate dropped dramatically, people would come in and say, we'll collect $1.5 billion less dollars over the next 5 years because our allowance rate is as low as it is versus what it would be otherwise. That didn't matter because we had to do what we thought was the right thing in terms of each and every patent. But the problem with that is you have to think about an agency that's going to make $1.5 billion less dollars. Does that put any pressure on anybody? So there is a sense that there was, and there was a fiscal crisis that occurred soon after I left. I don't want to make that sound like it was my fault. It was with the recession. Actually, the whole entire recession was actually my fault, so I should know. There is an issue there. I think integrity plays a role. We can argue what that is, but there's no question that there were people who were important, who mattered, who knew, wow, the office, is it really going to be able to fund itself if it can't bring in the kind of money that it's needed in the past. And the other thing is I'm a little bit ahead of my time politically because is everyone familiar with Rick Perry saying that the Social Security system is a Ponzi scheme, and that created a lot of... So when I was at the Patent and Trademark Office, I said publicly one time that the whole funding system is a Ponzi scheme. And I was told, my God, that's too controversial. You can't say that. So I literally said, okay, I'm going to start calling it the Social Security system. And everyone said, that's fine. Everyone was fine. You're right. It's very much like the Social Security system, not like a Ponzi scheme, though. But the bottom line on that is we collect your fees today. We, the Patent and Trademark Office, collect your fees today. It takes about 3 years to get a patent. Depends. It can take anywhere from 1 year to 5 years, depending on where you are. But your fees are collected today, and they're spent this year. But your application doesn't get examined until 3 years from now. So this system, which we talked to Congress about, my gosh, do you realize what the problem is here? You have no incentive to save money. The way we saved money, we had to hide to save money. So at the end of what we would do is try to save money throughout the year. And when we had a budget where we maybe came out $80 million or $100 million ahead for some reason, we would forward fund contracts. That's how we saved. You can't literally put it in the bank like a normal business and decide, well, I'll use that money later and I'll match it up with the application. So we had a sort of a ridiculous way of saving. So there's a lot of interesting problems there. The other thing that I would say that's a big problem is the policy is very lawyer-driven. I'm an attorney. I'm a lawyer. I'm not a patent attorney. A lot of patent attorneys who are out there were glad to see me leave. So when I first came in, I focused most of my reforms were focused internally on the Patent and Trademark Office, and that was really quite welcome. What wasn't very welcome was we also said, listen, we think there's inefficiencies in the system that are actually beneficial to attorneys and others. But we think we need to address those as well. And you can argue whether they were good, bad, ugly, whatever you want to argue about. But I would say that one of the things that I thought was a big problem while I was there was many different attorneys groups that would come in and say, you got to think about your customer. And I'd say, well, I am thinking about my customer. And quite honestly, the customer's not a patent attorney. And quite honestly, the customer's not even the applicant. They're a very important part of the process, but the customer is the American people overall. And so the point is we have to get the system exactly right. But there are many times where businesses and attorneys, I would say CEOs of companies, were not always aware of some of the programs that we had in place that, balancing risk. So here's I'm not anti-attorney, I'm not anti-government. I love both, and I think that they both do incredibly well. But what I would say is if we're about a system that's incredibly focused on innovation, one of the things that I find sometimes difficult for attorneys and sometimes difficult for engineers, and in terms of patent attorneys both being the same, sometimes what can be difficult is that as attorneys we're trained to identify risk, and we do it incredibly well. Attorneys identify risk incredibly well. I don't think in the patent system, being policy-driven from a lawyer perspective, I don't think we balance risk incredibly well. So a lot of the policy decisions that are being made, risk is identified, that's fantastic, but then the answer is run away from the risk. We don't balance it, which is totally and wholly inconsistent with entrepreneurship, innovation, and everything else we need to do. So I think one of the most important things that is out there in terms of what's happening with patent policy and everything else is we need people who balance those risks in a different way. And to be honest with you, there's a void because, the patent attorneys are incredibly vested in the system. They are incredibly intelligent. They are, in lots of ways, keepers of the system in terms of policy. And we need people who are more have a different perspective to really seek their voice and be heard. Have I already gone over time?
Yes.
Okay. All right. Can you indulge me for the video, or should I wait
absolutely.
on that? Okay.
We can always indulge a video.
I will, just brief introduction to this. While I was at the Patent and Trademark Office, we wanted to hire 1,200 examiners a year, and I found out that was whole percentages of people that we were hiring who were U.S.-born engineers. Maybe one of the biggest problems we have in terms of innovation in the United States is, are we inspiring enough people to get involved in innovation? I would argue that we're not. My son is a senior in high school in New Hampshire. They recently discovered they're the #1 high school in New Hampshire because they memorize better than anybody else. So I think the point of it is, first is an organization that inspires kids in the same way that we inspire kids in a sports model, et cetera. And I can't do it any justice other than to show the video. So let me show you this right here. By the way, this is from Morgan Freeman, famous actor. We didn't ask him to do this. We certainly didn't pay him to do it. He saw first and said, I want to do something to help people understand how important this program is.
This is the Super Bowl. The Super Bowl of smarts, that is. It's a life-changing competition. It's kids having fun, competing, working together to dream up, design, and build robots.
It's just an exhilarating feeling. It's like I'm using power tools.
They're having the hardest fun they'll ever have. And they're becoming our next generation of engineers and innovators. First, come out! For inspiration and recognition of science and technology, my teachers were some of the greatest influences on my life. By challenging and trusting me, these mentors got me to understand that I could do anything I put my mind to. First mentors are changing kids' lives every day. Professional engineers, teachers, parents, teaming up with young people not just to build robots, but to build confidence and self-respect.
I'm around people that I can get along with, that we can talk computer lingo with.
FIRST was founded by one of our greatest inventors, Dean Kamen. Dean saw that kids mostly look up to sports heroes and movie stars.
So we said, if we've got a culture now that's obsessed with sports and entertainment, let's inspire these kids to be big thinkers the same way Shaquille O'Neal can inspire them to spend dozens of hours a week bouncing a ball.
Our president agrees.
Scientists and engineers ought to stand side by side with athletes and entertainers as role models. And here at the White House, we're going to lead by example. We're going to show young people how cool science can be.
250,000 kids aged 6 to 18 compete at all different levels. In 2 FIRST Lego Leagues, the FIRST Tech Challenge. Then at the high school level, the first robotics competition.
The only difference between this sport and all the others is every kid on our teams can turn pro. There's a job out there for every one of these kids.
Students who take part in FIRST are 50% more likely to go to college and twice as likely to major in science or engineering.
I definitely know that I want to pursue engineering.
Once they've tasted what the power of knowledge is, that it can be fun and rewarding, they won't go back.
There's no doubt FIRST works.
10 or 15 or 20 years from today, some kid in those stands will have cured Alzheimer's or AIDS or cancer or built an engine that doesn't pollute. Look at these kids. They're the future.
I feel like I can go and do anything I want to do because of this program.
Someone took the time to guide and inspire me. It changed my life. Take some time. Go to usfirst.org.
Thanks.
John, that's a tough act to follow, but luckily, with that record for being influential, I think we'll...
Well, here's where I under-exceed expectations. So my presentation is fairly simple, which is good because we're trying to keep cut down on time. Okay, so I'm going to talk about the connection between innovators and entrepreneurs at a very theoretical level, and then I'm going to talk about some details. At a very theoretical level, what's the similarity? We can ask, what's the similarity between innovators and entrepreneurs? And I'm going to give you the punchline and then the explanation. The punchline is the production of information. And let me go through and first talk about innovators. And here is a basic question that is at the foundation of patent policy, which is why favor innovators. And this has historically been a huge controversy. So here's a quote from Sir Arnold Plant. You know that means he's a British economist because he's Sir. He's a knight. This is what he said in 1934. He said, he was skeptical of the patent system. What grounds are there for concluding that the output induced by this type of monopoly, meaning the patent monopoly, has any greater claim to be regarded as generally useful than that which would have been induced by the price conditions of the open market? And he suggested that such a conclusion runs counter to all general free market economic presumptions. That's my summary, but trust me on that's what he was saying. There's a general modern answer to this question. He was a skeptic of the patent system. The general modern answer is the person who innovates and otherwise would not be rewarded by the free market because the person produces and discloses information that can then be widely spread throughout society, can be widely spread throughout competitors, and they benefit from it too. And that's why we need to favor by rewarding through monopolies and also through other social subsidies, which we also socially subsidize innovation in a variety of ways. The patent system is only one way. So this theory is the production and disclosure of information. And we know sort of more about the economics of information, about how it is oftentimes like a public good, and that it can spread throughout society. And that's a fundamental touchstone for why we're doing this. We can ask the same question about entrepreneurs, which is why favor them? Why should there be a Kauffman Foundation? Why should we not just say, well, entrepreneurs happen to be, pretty good at doing what they do. But what we should worry about is starting businesses or hiring workers or doing other things. We shouldn't necessarily focus on one class that does that because, after all, old and established businesses also hire workers, keep workers employed. They start new lines of businesses. The traditional definition of an entrepreneur is somebody who takes risks, trying to move resources from lower productivity to higher productivity. Now, I say take risk because that's an important part of it. If there were just big signs out there in society that said lower productivity, higher productivity, right? And the entrepreneur would be somebody who would say, okay, I just take these resources, let's say money in a bank account, move it from the 2% return to the 5% return, we wouldn't think that person is really somebody that needs a lot of incentives to do that or needs a lot of help to do that. But the difficulty is we don't know what is higher productivity and lower productivity. There's a lot of people who are unemployed today. they're not producing a lot as unemployed. They'd like to be employed, but they'd like to be employed in something that is productive. And the question is, what will be productive for any person or any line of business that is trying to figure out what to do in the new economy? And that is an information problem. That is fundamentally an information problem. And that's what entrepreneurs do. That's why we favor them to some degree. And that's why the Kauffman Foundation, I think, makes sense, in the sense that we want to study entrepreneurs in part because they're like innovators. Even when they don't produce new technology, they may produce information about what lines of business work and what lines of business don't work. Okay, so that's the high theory and sort of a deep connection between what's similar between entrepreneurs and innovators. Now I'm going to go to, the title of this talk was Theory and then the Details, and it should be like the devil and the theories and the devils and the details too. How does this influence the very specific things that are in law? Because as stated in the introduction, I started with a physics background, and physicists don't care at all about theory unless it tells you something about something that goes on in the real world. So I'm going to give you two examples of things where I think we have forgotten an insight that used to be in law, which is that people who build businesses do disclose something. Okay, so here's something called the paper patent doctrine. It's something I'm writing about, something I'm researching over the last, let's say, 18 months or so. This is something that is not imagined by a law professor. This used to be the law. The law of the United States at the beginning of the 20th century used to be, if you had a patent and you had never practiced it, you had never commercialized it, that patent was viewed with, it was not necessarily per se invalid or anything like that, but it just was viewed as less rich and less solid than a patent that had been used to build a business successfully. That doctrine declined in the second half of the 20th century because there was this rise and triumph of a theory that justified patents solely on the disclosure in the patent document. This was sort of an impoverished view of information theory, that what we're trying to foster in society with patents is paper disclosures that you'll find in the patent office files. And that's a very, very poor information theory. Modern theorists of information would say there's not only information in a document, there's also a lot of other aspects of information, including something that's called learning by doing. And I think John's foundation is basically trying to solve that problem, learning by doing, having children learn by doing things. Probably nothing that they do, or most of what they do probably is not patentable. Probably a few probably might do something like that, but even the things that they do, I'm sure there are, but even the children who do not patent are gaining from that, and they're gaining because learning by doing is a real important part of the economics of information. The decline of the patent, the decline of the paper patent doctrine, the decline of this appreciation that there's more to disclosure than just what's in the files of the patent office has been great for so-called patent trolls. Patent trolls is a sort of, it has some problems saying that, but there is a reaction to in the modern world to people who just create a patent and don't practice it. And I thought a lot about that. Why is that a problem? The classic, the sort of modern theory of patents, it's just about the disclosure that's in the patent system, can't explain why people have this revulsion towards patent trolls. But the more older theory could. It could say, no, patent trolls, somebody who never built a business, they're different. They're different. And we're not saying they're terrible, but we're just saying that they have to be treated in a different way, and they used to be. And of course, entrepreneurs and people who actually produce things, manufacture things, the fall of this doctrine has been terrible for them. I think a revival of this would be a good thing, and I think it requires a theoretical shift, that the disclosure we're trying to foster with the patent system is more than just the disclosures of information that wind up in the patent files. It's disclosure in the real world, the teaching of a workforce, how to make something, the teaching of consumers, what's valuable about your new product. All of that is an information-rich activity, and we want to encourage the entirety of it. So that's a detail. That's a sort of modest little detail in which the law could be changed back to something that I think would help entrepreneurs and actually help manufacturing in this country, and I think be consistent with modern information theory. Here's another detail. This is the last one I'm going to talk about, which is a very new one, which is there's a new patent law, as we've heard mentioned several times, signed into law last week. This has, the old law was that the first inventor is entitled to the patent. And entrepreneurs kind of like that because they think, you know, I don't hire lawyers. I go out and do stuff. That's what I want to do. That's what I'm good at. And they like the idea that if they did something, meaning actually innovated, they were going to be protected as the winner in this game, not somebody who just was faster, had a faster lawyer than them. Now, the new law says that the first inventor to file a patent is entitled to get the patent, to file a patent application. But there's an important exception, which is quite radical in the world. The most important exception is that you can effectively secure a priority to a patent by publicly disclosing. I have these words in quotes because that's the statutory language. Publicly disclosing the invention. And then you get 1 year to file. You have to eventually file. You eventually have to file a patent application. So you eventually have to hire a lawyer. But the innovator wants to be able to focus first on building the business. So the crucial question with this exception, which is extremely important for entrepreneurs, is will the work of the entrepreneur in making and selling the innovative product, will that be an act of publicly disclosing, viewed as an act of publicly disclosing the invention? And I think yes answer to that question is the right answer and would recognize that the disclosures typically made by entrepreneurs are disclosures to the public. They're teaching people how to make something and that is valuable. A no answer would I think, limit this to sort of documentary disclosures. And we'd be very good as a nation then. It would sort of foster us as a nation of creating lots of paper, but not lots of things that are innovative. And I think that those are just two examples. I could go on for many minutes, but I think I'm coming to the end of my 10 minutes, so I'm trying to wrap it up here. This is sort of a little thumb sketch of an important insight about the connection between entrepreneurship and also why we should think about some of the crucial details in the law about how we deal with innovators and whether we recognize, or how we deal with entrepreneurs and whether we recognize the full value of what they're giving to society. Okay?
Thank you. Very thought-provoking. Doug? Maybe I could ask you to even be briefer so we can squeeze Steve in before we lose the web, and then we'll come back and give more time.
Let me just get this up here.
Terrific.
My background encompasses not only work on these legislative issues on the Hill, in the Senate and the House, so I'm actually a member of both fraternities. So having been at the Patent Office in a position similar to John's, the number 2 in authority of the Patent Office, and it's often not noted, but our great laborious effort to pass this patent bill, which is a very important bill in terms of many of the improvements that it makes for for the system, is actually, though, about the third major patent reform in the last, call it 20 years or so. There was a bill passed in '99, and before that, in '84, there was a measure that I worked on which established the Court of Appeals for the Federal Circuit. Now, John mentioned some of the challenges that he faced both entering and exiting the Patent Office, and I'm happy to say that we had most of the same issues, which is difficult issues with quality, issues with amount of time in examination, delayed examination, and the end of fiscal crisis as well, which this was in '92 when I left the Patent Office. So being in the Patent Office and then on the Hill, and then I was very fortunate to have the opportunity then to go to work with Intel Corporation, working on legal and technology policy issues for Intel. And that was a good sharp slap in the face, because whereas on the Hill or in the agencies, you have a lot of time to consider the ivory tower view of the world and how can the system be restructured and how can we move forward from a policy standpoint. In the private sector, basically at Intel, it was every day was pretty much how much money are we going to make today and how can we make more of it. And that was a daily challenge and a daily focus, the bottom line. Well, considering that these years of working with IP from both the policy and the practical application teaches to me the extraordinary importance of patent and copyright, and not to neglect trade secrets as well in this. This slide that I have up here talks about the increasing share of market valuation of top U.S. companies, which is now more and more based on intangibles. This was touched upon in the previous panel. This comes from a study done in 2007, Shapiro and Pham, there it's noted. And Peter, it may have been one of those paid-for studies, but the data on it's pretty good, and you can find it on the internet. But you can see that basically, looking at that period from 64 to 05. I'm sorry, that's a typo. That should say 84, not 64. But from 84 to 05, that the intangibles went from 25% of corporate asset values to 64% by 2005. Now, when you look at the top industries investing in R&D, those are also the highest in wages, salaries, and sticky and job growth. So this is a pretty good proxy for the value of the knowledge economy. The industries that are, invest the most in R&D, and this was from 05, and I think it's probably pretty much the same today with some growth in other sectors, but pharma, telecom, semiconductors, computers, synthetic fibers and resins, advanced chemistry. The interesting thing about this is the high-tech companies worldwide are the top patent filers. All the names that you conventionally think of as high-tech, IBM, Canon, Intel, Toshiba, to name some. The most profitable industries, when you look at that list, is a little bit different, but yet many of those are rapidly growing now in patent filings, reflecting the growth and realization of the importance of IP. That includes oil and gas, finance, and the data analytics industries, software and business method patents, think Google and Facebook and those kind of companies. Now, the visceral importance of protecting IP rights, since they underpin so much wealth creation, leads to some complex strategies for protection with some subtle shadings in approach, depending on whether the competition focus for companies, anyway, is domestic or conversely foreign markets. I want to focus on patent enforcement strategies to illustrate some of the incentives that drive large multinational business players. Similar to zones of economic influence in the colonial period, particularly the early 20th century, which were imposed by colonial powers in areas where they had territorial dominance, patents, to focus on patents for the moment, unlike copyrights and trade secrets, are government-granted rights to exclude others from making, using, or selling the protected technology. So in that sense, we often got beat up in the office for saying, don't call a patent a monopoly. It's the right to exclude others from making, using, or selling. So if you want, it's a negative monopoly, similar to a zone of territorial domination, economic domination. Now, since in the case of patents, the monopoly has to be protected by private action generally and not public, unlike, say, for example, the telecom industry, where the monopoly of AT&T, in a sense, also depended on the regulatory power of the Federal Communications Commission and so forth. So unlike the old model, a striking aspect of the system today is the extent to which companies seek to acquire weapons of mass destruction kind of level arsenals to intimidate competitors. And the bidding war for the Nortel patents is a good and recent example of this. Most manufacturing companies seek to use these arsenals for defensive purposes, so to speak, to back off competitors or enable cross-licensing on reasonable terms to conclude, if you will, territorial conflicts. And thinking about territorial conflicts, it's striking the extent to which convergence of technologies has brought companies into border conflicts similar to nation states. And like nation states, the probing of these borders by competitors often trigger an effort to engage their sovereign powers. And the underlying economic causes of this is the need to maintain an adequate window of opportunity to exploit markets. That is particularly the key to success where product generation is a very rapid cycle, such as semiconductors being an example, 18 months generally between product generations. And the consideration for multinationals often is, does the IP regime encourage or does it inhibit the exploitation of the market in question? Now, my experience from observation was that this is the underlying reality which drives the evaluation of the IP systems and how useful they are and whether to use them and to what extent, and not, adherence to abstract principles of IP protection. When companies are trying to advance the competitive strength, in foreign markets, the importance of a rules-based system is vitally important in order to encourage an outcome-neutral administration of the laws. If you're an outsider coming into a foreign market, it's most important for you that there be some defined body of rules that kind of set forth, here's the ground rules by which everyone plays by, so you can have a sense of certainty of where you're going in terms of how your rights will be treated. That favors domestic companies in the U.S. entering into foreign markets. TRIPS provisions of the GATT are an expression of this orientation. However, when the challenge is protecting the domestic market from domestic or foreign competition, companies often oriented toward outcome-based balance of equities approaches to the challenge. In this environment, and think about competition domestically in the U.S., gaming of the IP processes and indeed of national policy instruments like Congress and the regulatory agencies are very favored tactics. And the ITC, the CFIUS, Committee on Foreign Investment in the United States, and Buy America provisions are all expressions of the domestic market strategies and orientations. One issue is to realize that patents are strategically important in this, as we think about it in terms of patent policy and how it affects and drives our economy, but they're not strategically decisive. So the issue we have now is not, as in the old days, a crisis of the commons, which I'm sure everyone's familiar with. If you have the green out in the town square and everybody grazes their cows there, at some point in time the green is exhausted. The crisis, or I mean the issue in the knowledge capital and economy is how to grow the commons of ideas. So industrial dominance in the past, proximity to markets and natural resources was a key. But today, proximity to idea generators. And given the fact that materials, design, and production of parts can be accessed and performed anywhere in the world, protection of access to intellectual capital and the window to exploit the ideas is crucial. Now, since all national economies pursue the same general strategies, process progress, for example on patent harmonization, is countered by structural market impediments that are erected through, for example, antitrust enforcement, standards criteria, or national policies geared towards indigenous innovation. Again, as national economies, our competitors see the need to protect the access to intellectual capital and have a window to exploit it. These kinds of responses in the policy world are amenable, really only to slow and cumbersome international treaty processes for solution. Now, lest any sector feel superlatively virtuous, I just want to point out that labor union opposition, for example, to the U.S.'s NAFTA open trucking commitments is little different from the use of the International Trade Commission to oppose product introduction into the United States market. And the focus, in a similar sense, a focus on aggressive patent litigation strategy is really, practically speaking, a little different from attempting to enforce a 200-mile coastal economic zone in the open sea. So what that brings us to is I think that there are three general principles that guide the business sector here, and there's a caveat that I'll touch on that's unique to the United States. The strategies to succeed basically boil down to this. What companies orient on is inhibiting competition in domestic markets to secure the window of market opportunity by any means possible, and when it is advantageous to argue rules-based principles, that's the case, and when it's advantageous to talk the equities and balancing the equities through other means such as legislative interference or regulatory interference, then that's the strategy pursued. At the same time, protecting the window of exploitation in foreign markets from non-IP countermeasures through rule-based systems such as the GATT and so forth. And so rules-based policies are broad and flexible fairness domestically. The caveat uniquely in the U.S. and a small handful of the G8 countries, we advocate the principle of the level playing field, by which we really mean we want outcome-neutral policies implemented in foreign markets, but not only do most of our trading partners find this a completely alien idea, but they easily undercut our principled position by pointing to U.S. deviation from this principle in domestic policy. And at one and the same time, U.S. policy suggests both naivete and lack of principle. You can be naive and principled, or you can be worldly and unprincipled, but you can't be naive and unprincipled and maintain credibility. Now, to wrap up what I have to say, I want to just touch briefly on the future success strategies. I found very interesting the discussion in the earlier panel about the need of collaboration. And what my perception, having watched the system from a policy standpoint in Congress, from an administrative standpoint, working in the Patent Office, and from the standpoint of how it practically affects businesses is, that in the future, innovators are going to outrun the patent system. I believe that to be the case. It's just a matter of how long will it take. When I was at the Patent Office, we had about 175,000 applications. Last year, the Patent Office utility patents processed 490,000. And the time to examination is roughly doubled. It's now around 3.5 to 4 years or somewhere in that neighborhood, and some technology arts are longer than that. There will come a point in time, which is probably rapidly approaching, where the pace of innovation and the success of innovators in getting their product to market is going to outrun this system. It's going to outrun the ability to do full examination on every application that's filed. And I think it's to the point now, I know John could give the current numbers, but the average patent examiner has somewhere between 18, how many hours?
On average, it's like 22.
20 plus or minus 10%.
Now, what happens when the number of applications goes from 490,000 to about 1 million a year? You can see that system is just, as they say, Norm Augustine, a former CEO of Lockheed, had a favorite chart he liked to put up showing, well, if we continue on this rate of spending for defense technologies, in about 30 years, it'll cost $1 trillion to build the next generation fighter. Well, that's, as commonly said now, it's not a sustainable path. And I think where we are now is, in the end, not a sustainable path. I think you'll see a movement towards crowdsourced solutions. How will they compensate the innovators in the crowd? Equity offerings as incentives. But the key will be rapid time from innovation to market. There was a great example of this in a publication I was just reading a couple of days ago, Consumer-Driven Innovation, an example of a structure of the challenge for scientists is to sort out the structure of a folded protein relevant to a particular virus of interest. And so they conceived of the idea of putting this problem out there as a game, as a puzzle challenge for whoever wants to tackle it. And they found that basically they got a solution to a problem that had been perplexing the scientific community for well over a decade in about 3 weeks. And why? They had so many people working on the problem, with so many coming at it from so many different angles of innovative, creative thought process, that the solution evolved faster. You'll see that starting to happen as the innovation companies realize the challenge is, okay, is it getting the patent? Maybe down the road that's an important, backward-looking factor in terms of protecting wealth. But the real challenge is how fast can we get to market with this idea? And increasingly, innovation will be outsourced in that way. And I think that ultimately means somewhat, maybe not, I put the death of the examination model. I'm not sure it's the death of the examination model as much as a coterminous model evolving, which is a registration model or a privity of contract, where basically you have an article of you have a registration system where you can take an article of manufacture and you can file a document that discloses the article in your innovation. And then after that, the question is, did another party have privity of contract with you to manufacture? With that, I'll stop there, Kent, and we have time for questions.
Thank you, Doug. Very interesting. Steve.
I'm going to be brief, not because I'm standing between you and lunch, but for 2 reasons. One, I just lost my millions of listeners. And secondly, because I think it's very perilous for a policy generalist, social scientist, to be speaking about intellectual property policy and law on a panel with 3 attorney practitioners, scholars, and former administrators of the patent system. I want to return to the Congressman's remarks and his apparent ambivalence about the America Invents Act, the patent reform bill that President Obama signed a week ago today. He indicated that he opposed it in part because it failed to preserve the funding stream for the patent office and protect it from being diverted by congressional appropriators, but he indicated that he had other reservations about it. And I think there is quite a lot of reservation about the American Invents Act. So I want to talk about that, and in particular with respect to entrepreneurs and innovators, and an element that's frequently associated with them that we haven't talked so much about, and that is university. But by way of full disclosure, I should tell you that I am part of the National Academy of Sciences, which is chairing the enactment of the America Invents Act, and frankly, patting ourselves on the shoulders for having produced a report 7 years ago that has largely come to fruition. So by my count, the American Invents Act includes at least 7 provisions that are consistent with recommendations we made 7 years ago. And if you consider more broadly than the legislation, if you consider a series of court decisions that have come down from the Federal Circuit and the Supreme Court over the last several years dealing with elements of litigation and with the criterion of non-obviousness, even more of our recommendations have found their way into law. And I might add, even administrative action has addressed a gap that we saw in the capacity of the Patent Office to analyze its own activities and their effects on the economy by creating a Office of Chief Economist. So we're very pleased with the result, but we recognize that there is a large course of naysayers, and they've focused primarily on the question of what the impact on innovators and entrepreneurs and universities is. For example, one law firm had this to say: the Act certainly favors large entities that have the resources to quickly obtain sufficient data that will enable them to be the first at the Patent Office. Accordingly, the bill greatly places small companies, independent entrepreneurs, and universities at a disadvantageous position. Senator Maria Cantwell was even more explicit. This is not a patent reform bill. This is a big corporation patent giveaway that tramples on the rights of inventors. And if you read the blogosphere, the commentary is much more intemperate than that. So I'm skeptical of these claims for a number of reasons, and some of them have been enumerated. The first is that the two major provisions of the Act that are frequently claimed to be anti-innovation, anti-entrepreneur, the conversion to a first inventor to file system and the adoption of a post-grant opposition system, we examined what limited evidence there was for claims that these would be disadvantageous to independent inventors, entrepreneurs, and universities. In 2004, obviously, we were relying on evidence that had been accumulated up to that point, and we haven't seriously looked at the evidence since because no one has asked us to. But we concluded that there was very little evidence for the claims that these would be anti-entrepreneur. The second point that John Duffy referred to is that a number of features of the U.S. system, which are unusual, have been preserved. One is the grace period, and its application depends very much on how it's interpreted. The other is the provisional application system, the ability of a poor inventor to file a streamlined application, and within a year decide whether to pursue a formal application. The third element is that the universities, in the process of lobbying the bill, achieved a couple of important carve-outs. One is that they achieved the enviable status of micro-entities, for which they are eligible for reduced patent application fees, by an order of 75%, so that an institution of the order of the University of California with something like a $6 billion budget and 300 or odd patent applications a year qualifies as a microentity. The other is that the universities achieved a carve-out in which their patents are not subject to the prior user right defense that is available for all other kinds of patents. I think there's a subtler question which has been alluded to a number of times during the discussion today, and that is whether the reforms that have now been enacted favor technological disclosure or greater secrecy about innovation and technological developments. And I think we've heard remarks that suggest that the disclosure function of the patent system is even more important than it has been in the past in an era of open innovation and, as we've heard repeatedly, collaboration. So I think this is an open question and one that bears a lot of examination over the next several years. The provisional application, the grace period, would seem to favor disclosure, but many claim that the prior user rights defense is going to favor greater secrecy. And that's something, as I say, we should look carefully at over the next several years. Finally, I want to observe that there has been a sea change in patent policy. John Dudas indicated that patent policy is driven by attorneys, and that's certainly true. But in the last 15 years, the discussion of patent policy has broadened considerably. And what is also important, there's been a flowering of research on the patent system. And it involves not only economists and other social scientists, but law professors who engage in empirical work as well. And so I think we will see over the next several years a serious effort to look at the impacts of the new law and to evaluate them. And I think that's a very positive development. Finally, I agree with those who have observed that the new patent law basically addresses an agenda that is now 10 years old. And new issues, new problems have arisen that deserve careful examination. And so I certainly support the idea of a new effort to look at the patent system, and the Academy would be happy to be a part of that. Thank you.
Thank you, Steve. And thank you for